And welcome back. So in our session today, we're going to be talking with employment lawyer Charlotte Turnbull. And we are going to be talking about employment law, which is something you need to think about, even if you have got no intentions of employing anybody else for the foreseeable future. So let's kick off with hearing a little bit about you, Charlotte. Tell us a little bit about yourself.
So my name's Charlotte Turnbull. I'm an employment lawyer. I've been practicing law for around 15 years now. I absolutely love employment law. It's, in my opinion, one of the most interesting areas of law, mainly because it really has an impact on people. The law changes quite frequently and it really has an impact on people's lives. And I'm really passionate about promoting good employment practices and making sure people create great places to work.
Great, sounds interesting. So let's go back to that need to know a little bit about employment law and contracts, even if you're not employing somebody, because it actually matters. You have to think about your contract with your ex-employer, don't you?
That's a really important point, actually. Often these days, especially people that are in quite senior positions, they'll have what's called restrictive covenants in their contract, and they generally will survive termination. So that means that after you've stopped working for somebody, they can still stop you from doing certain things if it's contained in your previous employment contract. So for example, the classic ones are they won't allow you to work for a competitor. But what if you want to set up your own business? If that business is in competition with your former employer, you might not be able to do that. If you do that and your employer are unhappy about it, they may well bring a claim against you in the courts for an injunction to stop you from doing it. And if they're successful, you might be made to account for your profits. So that means any money that you've made in that period of time which you shouldn't have been doing it, which might be 6 months, it might be 12 months, any profit that you've made, you might have to give to your former employer.
Oh gosh, that's not good, is it?
Yeah, and in addition to that, there could be legal costs. So if they were right to get the injunction, you're going to be liable for their costs of obtaining that. And injunctions tend to be quite expensive because they happen very quickly. You need to have 2 court hearings. So yeah, it can be a very expensive thing to do. So it's always best to check whether you can or can't do that. If you've got a restriction, there's nothing to stop you from actually just asking your former employer, saying, can I be released from this? Can we agree that I can go and do this? Some may agree, some may not. In that case, you might need to just stop what you're doing for a period of time. The other kind of restrictions that are typically in employment contracts relate to clients. So you might not be able to poach or solicit any clients for a set period of time. And also you might not be able to do that with staff. So if you've got somebody that you work with, that you get on really well with and you want to start a business with them, or you might want to hire them to come and work for you, again, you need to check whether you're able to do that or not. So it's always worth checking whether there are any of these restrictions in the contract, because it can be a very expensive mistake to make.
Okay, so a couple of questions. I presume it's quite draconian to say that you can't go out and start another business. Are these restrictions often in place for a certain amount of time?
They are. So the contract will usually state how long they're in place for, and it tends to be 6 months or 12 months. If we're actually defending an action, say your former employer does bring a claim against you, or they try and bring an injunction against you, the starting position is always that restrictive covenants are void for being a restraint of trade, because it's not fair to stop somebody going out making a living. The courts will then look at whether it's reasonable. So if you're in a fairly junior position and you've been asked to not do anything for 2 years, that's never going to stand up. If you've been in a very senior position and your restrictions only last for, say, 6 months, they probably will. The court will probably say your previous employer has got a legitimate business interest to protect, and therefore we're going to uphold it. So it really does depend on the circumstances, but there's always room for a good argument on it.
Yeah. And I guess redundancy doesn't make any difference whether you've been made redundant, sacked, whatever. Yeah.
Well, in relation to a redundancy situation, often if employees are asked to sign a settlement agreement, it will state in there that those restrictive covenants will continue. So it just restates it so people are really aware that they will still bite. The only exception to that is if somebody has been constructively dismissed or wrongfully dismissed. So if the employer breaches the contract, they can't then expect to rely on those clauses later.
Okay. So yeah, because we might have people watching this who've been with their employer for 10, 20, 30 years and finding an employment contract, which of course would then probably be in paper, might be pretty darn impossible. But, looking at their redundancy agreement would be the way to find out if they have a restricted covenant. Yeah.
Absolutely.
Okay, so obviously that's to do with your ex-employer and restrictions on you. So let's assume that all's good and you can set up on your own, but you still have no intention of hiring somebody. So you said something quite interesting to me about, well, you still need to know about employment law because you might be hiring yourself. So obviously that sounds a bit odd, but tell us about that.
So firstly, I have to give a caveat that I'm a solicitor. I'm not a financial advisor, I'm not an accountant, and I'm not qualified or insured to give advice in that area. But what comes up quite often is people will start up their own business. They'll incorporate, so it'll be a limited company, and they will choose to pay themselves in a particular way. And what they'll do is they'll be an employee for a set amount of money, often tied in with minimum wage or a tax threshold. So they do that under PAYE, which means that they've obviously got that paper trail. They might make some national insurance contribution as well, so it protects their pension. But the tax liability is very low on a low salary. And then the rest might be paid by way of shareholder dividend. So it's just a different way of structuring how one might pay themselves. Like I say, I'm not qualified to advise on that, but I know that this is what a lot of people do. So if that were to happen, you don't necessarily have to have an employment contract. The law does say that there's certain information you must give to an employee, but quite frankly, in reality, no one's going to sue themselves. The founder of a business isn't going to sue themselves for not complying. But it might still be useful to have a contract because you might find that you need some evidence of employment. So you might need that to claim certain government benefits maybe. Again, that's not an area I'm qualified to advise on, but if you are in receipt of certain benefits, you might need to prove how many hours per week you work or that sort of thing. Or additionally, you might need it for getting a mortgage or for entering into a tenancy agreement. So it is not necessarily essential, but I would recommend it to be good practice if you're going to structure your business in that way, where you're going to be an employee and a shareholder. It just makes sense to have it just done properly.
Yeah. So I'm guessing, as you said, it would include things like the hours that you work, obviously the salary you're getting paid, holidays, hours, all the usual basics.
Yeah, exactly that. And it just makes it nice and neat and tidy if you've got everything papered up in case you ever need it in the future as well. So like I said, that part isn't mandatory, but I would generally recommend it, especially if you do need to rely on documentation for other things such as a mortgage or something like that.
Yeah. Okay, that's good to know. So business is going well and you're thinking that you need to take somebody on to help with, I don't know, admin or sales or whatever it might be. And I mean, there are two different ways of going, two paths here, aren't there? There is taking somebody on who's part of the company, who's an employee, and there's going with the independent contractor or associate, whatever you like to call them. So tell us the difference from an employment law point of view with the two alternatives.
Okay, so an employee is somebody that is an employee. They work under a contract of employment, often exclusively for one employer, although they can have more than one jobs in employment. They'd be entitled to various employee rights, so the right not to be unfairly dismissed, the right to statutory minimum holiday pay or holiday time, and other sort of employee related issues, including actually a pension. Since we had auto-enrolment a couple of years ago, employers now have to pay pension contributions as well. Employers are also liable to pay employers' national insurance contributions, so that's an additional cost on top. An independent contractor or an associate or a self-employed person is somebody that genuinely provides services to you. They're not an employee. That would be somebody that has their own business, that provides a service to you, and then they produce an invoice and you pay their invoice. On the face of it, that all seems really straightforward. However, there's a bit of a blurred line. For quite a few years actually, a number of people have been calling themselves independent contractors because they can tax themselves in a slightly different way. So they don't pay tax under PAYE, they submit a tax return. And also the employer doesn't have to pay employers' national insurance contribution. So it's cheaper for the business, and the employee generally earns more money. Now, the government aren't happy about this, unsurprisingly, and they're going to be changing this. It was supposed to happen this year, but because of the global pandemic, everything's been put on hold. But next year, there's going to be some changes to what's called IR35. So there's a particular test to how you can tell whether somebody's an employee or not. And I think this is where new business owners might need to be a little bit wary. So if they are hiring somebody to give them a bit of support, they might think they're in a genuine, hiring a genuine contractor to do that, such as a virtual assistant, for example, but they might not be. So if there's a virtual assistant that provides support to, say, 10 or 20 businesses, and he or she does a couple of hours a week for you, depending, any day doesn't really matter, any time of day doesn't really matter, they're probably a genuine contractor. They've got their own business, they do this for lots of other people, they'd submit their invoice. If, for example, you had somebody that on paper had their own business, but only really worked for you, even if that was the equivalent of part-time hours, there might be an argument there that that person is actually your employee. It's a little bit more complicated than that, but it's always worth double checking that the people you're working with are genuine contractors or whether they're actually your employees or not. If you're working with somebody as a contractor and HMRC deems them to be an employee, there's quite hefty penalties. So you have to pay all the tax, all the national insurance, and then potentially a penalty on top. So it's really worthwhile just double checking those relationships that you have with people as to whether they might be deemed to be an employee or not.
Okay, so that sounds sensible. But I mean, in reality, how do you do that? How do you sort of say to people, how many clients have you got? Who are you working with? It's...
One of the main things that we can look at is actually whether they're free to work for anybody else. So if somebody wanted to, say, only work part-time hours and all of those working hours were working with you, in reality, they haven't really got any time to work for anybody else, so they might well be your employee. If actually they only work for you, but it's because they're trying to build their own business and they want to work with other clients and you have no objection to them working with other clients, then they're probably independent. So it really is how much control you have over that person. So if you tell them what to do, when to do it, that they can't work for anybody else, they're probably your employee.
Yeah.
If actually you don't really care, they can do it at midnight for all you care. They probably satisfy the test for being an independent person.
Okay. So it is a sort of a blurred line area that you have to talk to people about, really, communicate. Yeah. Okay. So, let's assume that you are. First, let's assume that you are going the route of having an independent contractor associate. I know, for instance, with virtual assistants, they often have their own terms and conditions and so on that you use. In general, is that the norm, or is it worth having your own terms and conditions for independent contractors?
I think if you want to avoid the risk of them being found to be an employee, in that instance, it's probably better to use their terms.
Okay.
Because you are then obviously contracting on their terms. It's showing that you don't really have the control over them. In respect of other aspects of your business, and this isn't employment law advice, this is just sort of general business advice, you might want to get all of your clients onto your own terms. But that's sort of outside the remit of my expertise.
Okay. And so independent contractors, if you're using their terms, then that backs up the case that they are independent contractors. So let's decide that, hey, it's time, the business is growing and you want to take somebody on. You want an employee, you want to be the boss. So what do you need to know?
Firstly, I'd congratulate any business owner on getting to that point. That's a massive achievement, that you're so successful, you are in a position where you can hire an employee. It's really exciting. The first thing I'd do is actually look at recruitment. And a lot of people will think, well, I don't need legal advice on recruiting somebody. I just put an ad out there on a job site and or just put a message on LinkedIn. Hey, everyone, I'm hiring. But unfortunately, it's not always as simple as that. First of all, I'd advise people to think about what the vacancy actually is and what the job description is. Make sure they know very clearly what they need somebody to actually do. And when they write the job advert, to actually be very careful that they don't inadvertently put anything in there that could potentially be discriminatory. We don't see it so much these days, although it has been brought to my attention recently. Obviously, don't put anything in there like young person needed, or nice older lady needed for such and such, or something like that. You don't see it as much these days, but you do still see it. And in fact,
I remember seeing it. Yeah,
there was a charity, I think it was a charity recently, somebody shared this on one of my social media groups that I'm on, said that they particularly welcomed applications from women. I was like, why would you put that? I expect what they were trying to do is say, we welcome applications from people that want to work flexibly, or something like that, you know, trying to promote perhaps being a bit more family friendly. But to actually put in an advert, you know, we would love to receive applications from women. I was like, oh my goodness, it's 2020, what are you doing? So obviously make sure you don't put anything in like that. So the areas in which are called basically protected characteristics are things such as gender, age, race, religion and belief, and what's the other one? Disability. So if you were to put an advert out there that said require a young lady, a young Christian lady who's able-bodied, you know you're going to be breaking all of the rules there. So just make sure that you're not putting anything in there that's going to discriminate against anybody, or inadvertently discriminate against anybody as well. So that's clarifying what the vacancy is, working out what you actually want them to do, making sure your job advert complies with the law. And then obviously we've got interviews. So I would always recommend people write out a list of interview questions in advance, so they ask every applicant the same questions. So again, there can be no allegations of discrimination. And also just, again, be aware of the questions that you can and can't ask. The classic one is for women: are you planning to have a family, or do you have any children? Same questions that are never asked of men, which is a real shame, because okay, men can't biologically have children, but they might be the one that wants to take the time off work afterwards to look after them. Men are never asked that question. Women are asked it a lot. And even myself as a lawyer, I have been asked that question in interviews. Lawyers really should know better. So making sure that your interview questions are very neutral and that you ask everybody the same question. And again, you might want to consider, probably not for a small business actually, so I'm just thinking this through. I was going to say, you might want to consider sort of blind recruitment. So you ask people not to put their name or their age or their address or anything like that on their CVs. That would only really work if you was using an agent. I think if you're a small business, the reality is if you're doing your own recruitment, that's not going to be possible. But something worth bearing in mind for the future, because we all have these unconscious biases where you might see a particular name and unconsciously make a snap decision about that person, whether they're going to be a good fit or not. So if you are going to work with an agent, perhaps ask them to provide CVs that have been anonymised, just again to sort of make sure there's no unconscious bias going on.
Okay.
And then
the recruitment thing, you found the person, the right person, and I really take notice of what you said about the job description, because if you write a job description and actually when the time comes and they arrive and it's completely different, then you know, I'm guessing they may have a case against you.
Not necessarily. So employees don't really have any rights until they've been employed by you for 2 years, unless you discriminate against them on one of those characteristics I talked about a moment ago. So actually, if they turn up, the job's completely different and they're not very happy, there's very very little an employee can do. That said, I am all for promoting fantastic places to work, and I wouldn't encourage an employer to do that to anybody. It's not a nice thing to do. Yeah. And surely if you're starting your business, you want to create an amazing place where people want to come to work. I genuinely believe you get more out of people if you support them and create these, great places. One way in which we can do that is just making sure that everything is clear from the beginning. So making sure the job description actually describes what that person's going to be doing. When you've recruited them, actually making sure they are the right fit. So that's not just about their qualifications and their past experience. It's, do they believe what you believe? Are they on board with where you want your business to go? Do you get on well? That's not legal advice, but it's really good practical advice. You want to surround yourself with people that are going to make your business successful. So then we would look at just getting the basics right. So making sure that they've got the contract of employment and the basic policies and procedures in place. That means that everybody knows where they stand. So if there is a dispute in the future, it's very clear exactly how we can deal with it. So in terms of the contract of employment, I've seen it so many times. Clients go onto the internet, they'll Google contract of employment, they'll hash something together and they think it's okay. 9 times out of 10 it's not. Often sometimes those clients will come to me and say, well, I've done this, can you review it for me? And actually it's cheaper for me to just start from scratch and give them a compliant one. But in April this year, there were some changes to the legislation. It's called the Good Work Plan, and it's the government's attempt to modernise working practices. And since then, there's been a few changes in what you need to do. So Section 1 of the Employment Rights Act says you must give your employees a statement of their terms of employment. Previously, you could give that within 2 months of them starting. Since April this year, you have to give that on or before the day they start work. And that has to set out, so it's really good for employees, they know where they stand. It's good for employers, they know where they stand. It has to state the commencement date, their job title, their hours of work, their pay, the place of work, what happens with any pension contributions, if they're entitled to any training. So the employers have to give this. So it's really important that they get this right. Those terms that must be provided under Section 1, it's called a Section 1 statement, can actually be given in a contract of employment. It's much easier to actually just do a proper contract of employment from the beginning. In addition to that, it's useful to have a staff handbook. Again, it's not mandatory. ACAS have in place a number of policies and procedures and rules that if an employer doesn't have them, you'll fall back on the ACAS provision. But it's really useful to have things like a grievance procedure and a disciplinary procedure. They're the two that ACAS say you really must have. In addition to that, it might be worth having some kind of performance or capability procedure in place. So if actually your employee doesn't work out, you've got a way out. Yes, they don't have any employment rights until they've been with you for 2 years, but you don't know what they might say. If they're not doing a good job and you get rid of them and think, well, they've not got 2 years service, I don't need to do this properly. They might say, oh, they sacked me because I'm a woman, they sacked me because of my religion. So, why run that risk? Have proper procedures in place and follow them. If you have a performance procedure in place, you just follow it and you say, you're not performing how I want you to. This is what our policies say. This is what we're going to do. And actually at the end of it, if you're not up to scratch, you might be dismissed. And if an employee does then bring a claim, a tribunal is going to find it really difficult to find in their favour if you've done everything right. In addition to that, dependent on your business, you might want to have a bribery policy in place. Okay. Doesn't apply to all businesses, but if you are working in, say, financial services, or if you're working in developing nations, or if you're working in some kind of shipping, I believe bribery is still kind of rife in that industry, you might want to have some kind of bribery policy in place. All employers need to have health and safety. Again, the backstop is the law, but why not have a policy and procedure in place that sets out exactly what you should do? And also, you're probably aware of the recent changes to data protection. So a couple of years ago, we had GDPR and the Data Protection Act, a new Data Protection Act. So if you are hiring employees, you will be handling their personal data. which means you must register with the Information Commissioner if you haven't already done so. You probably need to do that for your business anyway. But if you're hiring employees, you'll definitely need to make sure that you're registered. It's about £35. You do it once a year. But also you need to tell your employees how you're processing their data. So you need to have a data statement that you can give to your employees and say, we will be processing your data and we'll be doing it in accordance with the law. So it's all really boring stuff, but it's stuff that you really need to do, because if you get it wrong, it can be very expensive.
Yeah, it's all stuff to protect you in the end. Yeah,
Yeah.
it's boring, but it does protect you. Yeah,
Absolutely.
Yeah. So as we are recording this, we're recording this in August 2020, and we have Brexit looming. Can you see that bringing many changes to the employment law and the workplace, or is it a bit of an unknown quantity at the moment?
It is a bit unknown. So a lot of our employment laws have actually come from Europe. So things like the working time regulations, they are a European regulation that we've implemented into national law here. That might change. I think it's doubtful. I think it also depends on the government in place at the time, whether we've got a pro-business government or a pro-individual government. I think it's really hard to say. Working time regulations might change. That includes your holiday. I think the government would have an uproar on their hands if they tried to reduce everybody's entitlement to annual leave. Again, obviously things like human rights comes out of Europe, but again, I like to think we're a civilized nation and that sort of thing isn't going to change either. I also think the government have got enough on their hands at the moment with obviously the COVID pandemic and Brexit, that I think they'll probably leave the employment laws alone for a period of time. They'll probably have other things to focus on, but anything could happen really. And like I say, if you have a real pro-business government, they might want to erode certain rights, maybe some kind of family rights, the parental leave, maternity leave. They might want to reduce holiday. They might want to increase working hours. We just don't know. I'm not expecting anything to change imminently, but who knows?
It's good to know. Yeah. Well, I think we've covered a lot there. Lots of things to think about, both if you are, setting up a new business or consultancy and you haven't yet checked your past contract, and if you're growing and you want to take on someone from the beginning. I mean, some businesses do, don't they? So lots of things to think about. And actually it's all there to protect you as well as your employees. So thank you, Charlotte, for today. And if there is a massive change post-Brexit, we'll get you back to tell us what's new.
Delighted.
In the meantime, Charlotte's LinkedIn profile and details will be below the video, so you can connect with her there. Lovely. Thank you, Charlotte.
Thank you so much for having me.
Bye.
Thank you. Bye.